on behalf of the appellant Certified Motors and Joseph N. Longer. We're here today to ask the court to reverse a final declaratory judgment which found no provision in the lease to become unenforceable and to remand for entry of the judgment in favor of my clients. I'd like to reserve 5 minutes, please, for the vote. We put the facts. Yes,
I'm happy with something. This original lease was below market.
Yes.
Whatever the reason was below the market. And I guess when I hear the other side, I sort of question, would it be reasonable to have a renewal that would keep you potentially on a 10-year track for below market rate for the lease?
The agent who represented the landlord testified that it was the intention of the landlord to continue that amount because of the amount of improvements that Mr. Enlager and Certified made to the property. So if there is an ambiguity about that, this case is unusual because we have that concession from the original landlord's agent that that's what the intention of the parties was at the time that the first lease was executed. We put in the brief a brief history of what happened after this lease was purchased by Aventine. And it is clear that they have created contextual defaults and breaches of the lease in their effort to do whatever it takes to get rid of Certified Motors from the premises. Now, the judge here agreed initially with the appellee's position that rent is an essential term of any lease, that the lease was silent, therefore it was unenforceable. And there were two cases that were presented to the judge on this. It would be the Edgewater case and the Goldman case, which was argued against the motion for summary judgment. And we argued that the judge was bound by it. She entered the declaratory judgment, a notice of appeal was filed, and then a motion to stay was also filed, citing the court again to these two cases. And to her credit, she recognized that she had made a mistake in her ruling and issued the stay to make sure that the status quo could be maintained until this court had an opportunity to decide the issue. The two cases we refer to are pretty straightforward cases. Both go before the court on the interpretation of the lease. The lease has an option to renew, and then the two cases that we cite to both Kidleck and Edgewater determine that the renewal is ineffective because the terms of the renewal are not definite enough. But each of them start with an analysis. And I think it's, I'll start with the Fifth District's decision in Edgewater, only because I think Judge Cowart so carefully crafted this, and it makes perfect sense. He said, in the opinion of the majority, options to renew can be worded in various ways. But what may seem to be negligible semantic differences can have a dramatic difference in the construction the court places on a particular clause. He then goes on to say, when the contract clause provides that the lessee shall have an option to renew for a specific period of time, but is silent as to all the other terms, the clause has generally been held sufficiently definite to enforce and construed as encompassing the same terms and rent as the original lease. So he's taking that on the one hand, and then what he says, on the other end of the spectrum, where the option to renew sets out that the terms, period of time, and rent shall be as determined by the parties, at the time of the renewal, the clause has generally been considered so indefinite that it is unenforceable. The cases that are relied upon by Aventine are all other of the spectrum cases, the other end of the spectrum. Our case, the other case that we cited the court to was Goldblum. In that case, the court says, Kislak cites a massive authority. There is none to the contrary, that an otherwise silent agreement simply to renew an existing lease implies that the renewed term is for the same rental as the existing one. So the flaw in their logic, as I see it, based upon these cases, they've argued, hey, wait a minute, there's a missing term, the amount of rent, and therefore that makes the agreement indefinite and unenforceable. The flaw in the logic is, hey, wait a minute, these cases say if there is an option and there is no reference to rent, the court deems that the parties have intended to renew on the same terms, thereby incorporating the rent as the first lease. That's the part of the argument that they have overlooked, in our opinion, in our view, in their briefing and made to Judge Thomas.
Well, I think relying on Edgewater, the opinion goes on to say that we hold that the better view is that the amount of rental is an essential element of the lease. And therefore, in this case, because there is no amount, that provision is vague and unenforceable. And I guess what there are other cases in that say that with renewal period, but then they have some additional language like pursuant to the terms of this lease. And so my question is, if we're looking at here, I guess it's paragraph 1 that has the term, and it says the term of this lease shall begin, and then it goes on to say that the tenant can exercise an option. Are you saying that because it is referring to the lease, the only thing you could renew is the lease, which by its terms include all the essential elements of what are necessary for a renewal?
Yes. That's what we're saying. Now, let me point out one other.
I think it's pretty simple than that. The concept of review is that we're going to keep going as we have been. Right.
If this is an insurance contract in which I've appeared before the court hundreds of times, I would be able to say, of course, a renewal is a renewal on all the same terms that otherwise previously existed.
But they both raise the rates.
Yeah, right. That's true. But the other thing I want to point out, Judge Smith, is if you go down in that opinion a little further, the court talks about the split of authority, and it goes, however, where the option to renew specifies the period of renewal, but specifically leaves the rent to be determined by the parties in the future, without specifying the method to be used, if the parties cannot agree, there is a recognized solid split of authority as to whether the clause is sufficiently definite enough to be enforceable. So the issue that was before the court in that case was one of those types of agreements, one that did not specify what the parties would do if they couldn't agree in the future. That's not what we have. We have the other end of the spectrum, the first one that they talk about, which is we have a renewal agreement that simply says you have the option to renew, and the legal presumption from that is it is going to be renewed on the exact same terms as the previous lease.
Other than the principle that if the lease is silent, okay, which is the scenario that we have here, are there any other cases in Florida that discuss that? Because it seems to me that the cases that the fifth and the third are relying on are cases from that state.
They are. It's general common law.
So this would be something new that the second, I guess, for the state would be deciding on this issue or not?
Well, I think the third and the fifth have stated what they believe the rule of law to be, which is that Florida would follow those other cases.
Okay, but is it?
You're not bound by that.
But in those cases, there wasn't a lease like we have here that was silent.
No, what they said was based upon the case law from around the country, which is not in conflict, that a lease such as this one would be deemed to include the terms of the lease it was replacing as a matter of law. It's not indefinite because the terms are soon to be the same as they were to the previous one prior to the renewal. That was the rule of law that was announced by both the 5th and the 3rd, and as a tool for their explanation for then following up and determining that the ones before them were not that kind of a renewal. It was an indefinite renewal because there was either a provision that you had to go arbitrate the differences, or that you would look at what the commercially reasonable price was for the renewal. That's not what we have here. And to the extent that there was even a doubt about that, the testimony of the parties who entered into the lease, it's uncontradicted. This is what they intended, that it carry over for another 5 years under the exact same terms as the December 17th one.
Could we, by implication, that did more about work case laws, not necessarily in our district, but looking at Strano, looking at Woodward, and by foil, essentially, the courts are the consumption that leads to one of the premises that leads to the conclusion that there was no renewal, or agreement, was that there was ambiguity as opposed to silence. For instance, a lease renewal connotes a continuation of the landlord-tenant relationship in the same terms as the original lease. However, in that case, there was something that upset that normal premise, which is that silence means it's the same term. And Woodward title 30, a lease renewal involves a continuation of the landlord-tenant relationship on terms specified in the option to renew, or if no terms are specified, then the renewal connotes a continuation. And that was the premise. And the fact that it was not silent led to the conclusion that there was no renewal. Could we work backwards that way? Say, well, if one of the premises of these cases is that if there's silence, then there is a renewal on the same term, and the lack of silence creating an ambiguity means no renewal. Is that good case law?
Well, I would think that to the extent Your Honor believes that there would be some type of ambiguity, that would open the door to parallel evidence. And
I guess my point is what I'm saying is there may be case law that accepts as a premise, even though the outcome was that there was no renewal, that silence implies the same terms are carried forward.
I think that's
all that counts for all other counts.
Yeah, I think I thought that was what the general rule that was announced both in Edgewater and I think that's the rule that they announced. And I understood your question to be, can that silence also be deemed some type of ambiguity?
No, yeah. So I wish I had the advocacy skills to not waste their time on that, but I meant the opposite.
Okay, well then, yeah, then I think the answer, at least that I would give you, is yes, it's straightforward. That's what they said in Edgewater and Goldberg was that precise point of law. And that's what we had argued to, not me, but my colleagues argued to Judge Thomas. And then we articulated for her in the motion for stay that she was bound by these rules of law, and we thought she appropriately entered the stay on that basis. This court's not bound by what the 3rd DCA said or what the 5th DCA said. We would ask the court to adopt those rules. They're common law rules that appear to be universally accepted throughout the United States. There's certainly not been any argument made in the briefs as to any public policy reason why this rule should not be deemed acceptable. And it seems to work in a commercially reasonable sense among reasonable people, that if they leave this term undefined, because it's, as Judge Cowart points out, it's when you go and attempt to define further all those terms and conditions, that's where you get into trouble. That's exactly what he talked about up front, where he says that the negligible semantic differences can have a dramatic difference in the interpretation by the courts. So this is the starting line. And these people decided to stay at the starting line. They didn't negotiate new terms. They didn't include new language. They wanted the definiteness of the starting line. And we believe that that's what they got and should have gotten. We also, in our briefs, asked the court to rely upon some cases, I agree with Aventine, they're not dead on point. They're at least forfeiture cases, but the same principles of equity would apply here. When you have uncontested testimony by both parties to the agreement as to what the parties' intentions were, and in reliance upon that, my clients invest a lot of money, more than $300,000 into the shell of a building, which was rented. That equity would seem to be to prevent this new landlord from coming in and advocating a position that's different than what the initial landlord agreed to.
And you're into your rebuttal.
Okay, I'll reserve whatever time I have left for my rebuttal. Thank you.
Thank you.
There's always too much people.
Good morning, Your Honors. May it please the court, Paul McDermott for the Appellee Aventine. This case asks a simple question, which is, does saying less in a lease renewal mean more?
Well, don't all the cases say that? Don't they all rely on that premise? In
Well,
other words, let me try to redeem myself, Counselor. Someone hopefully help me articulate. I am saying probably exactly what he's saying, but in these cases, many of which you even cite, I believe, in favor of your position, rely on a premise that supports the amount, which is that if the lease were silent, then we would have a renewal here. But the conclusion is drawn from the fact that, as opposed to a silent lease, the lease spoke to a way, a manner in which future rents would be determined, and that was what subverted the effectuation of renewal.
so what all of those cases we think stand for is this, is that the parties have to say something. And to Judge Smith's point, what the Edgewater court held.
But it's silent as to all their terms. Doesn't say like that they're saying the parties have to say something. Silent.
But that's not the holding, in fact, of the court's decision in Edgewater, or even
That's the point. Isn't the holding based on a premise that silence indicates a renewal of the terms?
But
Yes or no?
No, I don't believe it is. And what each of those courts, in fact, look at is whether did those parties to those leases say enough such that they had reached a definite agreement as either to the amount of the rent or a definite procedure to be followed should the renewal be exercised.
So in those cases, they never did it correctly. It always left something sort of.
Well, I think the parties didn't do it correctly. I think what the court concluded correctly is,
But
and what's the,
if you had said, you know, we would renew and the new rent is going to be, you know, it's going to be 10% above, or it's going to be tagged to the CPI. You could say that's not a problem.
I agree. And in fact, in Goldblum, the court affirmatively recognized that the language that the landlord struck on the face of the lease, as set forth in the lease, the striking of that language created an ambiguity as to whether it meant something the same or something different.
Language in and of itself drew that contract into question because it struck the language that it would be, you know, pursuant to those terms, whatever that language was. And by striking it, it questioned whether in fact the parties wanted it to be the same. And that's not what we have here. And if I could sum up the argument on the other side, silence is golden is what it seems here, that because it simply says nothing, that we're going to renew the way that it was before. And I don't know that Edgewater necessarily holds here, Goldblum, because it's talking about it's leaving something open for the future to be determined by the parties. And here we don't have that. And I think what you're trying to do with, I guess, it's Goldblum that has the striking language is rewrite the opinion to say that you have to have that language in it, but that's not what the opinion says.
So
the important that opinion was the striking called it into question.
That's right. And in fact, all Goldblum stands for is that where there was an ambiguity, the court determined that the parole evidence would have been appropriate.
Here.
None. We agree because the lease says nothing, because the lease contains no agreement among the parties.
That's why I have trouble with it. Your rules seem to be we're in a renewal context. there must be a stated rental rate.
That's exactly what Edgewater holds, and that's exactly what the other cases that cite Edgewater by the third and the first hold.
I think you pushed too far on those, but.
Well,
I hear what you're saying.
So let me explain it this way.
Reach that.
Sure.
The rest of the law says that, you have to specify the renewal, rental amount.
So it's at the end of the case, and Edgewater holds the amount of rental is an essential element of a lease, if not the basis for a lease. And an agreement to make a lease or to renew or extend a lease that fails to specify either the amount of the rental or a definite procedure to be followed to establish the amount of the rental is too indefinite to be legally binding.
But it does specify the rental amount. You know where it specifies it? In the lease. And in the same opinion, it says that's enough for it to have been specified during the original term. Because it says where the contract clause provides that the lessee shall have an option to renew for a specific period of time, but is silent as to all the terms. The clause is generally then held sufficiently definite to enforce and construe as encompassing the same terms and rent as originally read in parliamentary with that last paragraph you read. My only way of understanding this case is to say that there is a rental, there is a rent amount determined, and that is in the original lease. That's the.
Well, let me suggest this to the board. So the fifth and the third and the first and the Edgewater opinion, the Jahangiri opinion, LaFountain opinion, and the FM3 opinion that the trial court correctly followed in this instance, all determined that the parties in those cases did not say enough to have reached a definite agreement.
Well, they said something that's riveting down, right?
That's exactly right. But if those courts had concluded that silence was in fact enough after determining that the parties reached an indefinite agreement that could not be enforced, what they would be left with is exactly what exists here, which is silence. And if those courts concluded that silence was sufficient, they would have carried forward the rent that existed in those initial terms, as opposed to finding the renewals unenforceable. And that's what they did.
In those cases, though, the parties undertook to come up with a new lease rate. And the method they chose left uncertainty. Here, they said nothing. And if you go back to Williston before that, I mean, the concept of renewal is going to continue going forward on the same terms.
I agree. It's a unitary agreement. I agree with that premise. The problem is that if saying something that is indefinite is not sufficient to create a binding agreement, how can saying less be sufficient?
Say indefinite. I'm misunderstanding. What do you mean by indefinite? It says you can renew, you have the option to renew for a 5-year period. What are you saying is indefinite?
Well, in those cases, what the courts found to be here, there's nothing that's indefinite because silence is not enough. Edgewater, Jahangiri, even Goldblum, we think, stands for the proposition that the parties have to say something. They simply can't say enough.
Position seems to be at odds with what the commentators would say what the existing case law is as to silence.
I don't think so, respectfully, because what Goldblum, which is the case that the appellant relies on, and even the cases that the trial court we believe correctly followed here stand for, is that the parties have to say something, and as Edgewater describes it, one of two things: a definite amount of rent. And one way the parties might do that, as we think the court in Goldblum recognized, is they might say, as set forth in this lease. If this lease had said on the same terms and conditions as the original term, that would have been the parties reaching an agreement as to the amount of rent during the renewal term. They didn't do that.
If I'm entering a lease and I negotiate for a 5-year lease with an option to renew, I enter it thinking, yeah, at the end of 5 years, I can renew it. And there's silence as to any lease term, so I'm going to continue another 5 years. What needs to be said? And I guess I'd like your take on Mr. Vlach's point that there was testimony as to the intent of the leasing parties at the front end as to why we're going to have this long-running below market lease rate.
I'll answer that question second because I think it's an easy answer. This is the complete integrated lease between the parties. The testimony of the original landlord, the testimony of the tenant, which were presented, those were not part of what the trial court considered in reaching its result as set forth in the trial court's final judgment. Because this is an integrated contract, whatever the intent of the parties, is frankly irrelevant.
Anybody object to that at trial?
No, and this was on a summary judgment hearing.
Yeah.
And by the way, no argument has been made that this is an ambiguous provision that would require the provision of parole evidence.
You're just saying that enforceable because it doesn't include a term. So
That's right.
Let me go back, just describe, take a discussion, the situation in a different way. The renewal clause is silent, but the lease is not silent. That's the rent amount, correct? There's a rent amount in the lease, right?
As to the original term, I agree.
Yeah, so, Judge Rose mentioned Wilson. Well, counsel for the appellant cited Andrew, where the parties to a lease did not leave the rental amount for the lease renewal period open to negotiation. Which is the case, which is the scenario in all the cases you rely on, where they left the open in the litigation. The court looks at the terms of the original lease. Based on the premise that once the renewal period is exercised, the original lease is unitary one for the extended term.
And I think the Amjur case relied on a first DCA decision, bold MLP. And that lease contained language that says rent would be $800 and each subsequent year rent will increase 5%.
Which
That
is
court-
a problem in all, which is also a problem in all the cases you cited, which is different from this scenario.
Well, that court found that was actually sufficient to be enforceable. What the court said, language that each subsequent year necessarily would have included the renewal term. This lease says nothing. It says nothing other than rent is $5,000 payable on the first day of each month. It doesn't say rent is the same during the renewal term if exercised. It doesn't say rent shall be on the same terms and conditions during the renewal term. It doesn't say rent shall be at a CPI index.
What else could we throw into, what else could we imply to this example? It sounds like what are the other elements you need for you need rent, you need a term? Is that you're saying all you need is rental amount and term?
I think it depends on the premises, but in general, the material terms you would want.
Or the carrying forward. So you all spend a lot of, your clients spend a lot of money trying to enforce certain provisions of this lease against the tenant, right? That's part of the facts. You said, probably should have been put in the fact section.
And those claims remain pending.
What are those all terms that in doubt whether those terms go apply?
Well, we don't know, and that's exactly the point, because the parties haven't said.
Show me what a rent. So you're saying a renewal. What we want this court, if we were to say writing an affirmance, we would say that no renewal provision in a lease is effective unless it says renewal for 5 years according to all the terms of the original lease. In other words, there has to be some language that says not just the rental term, but all the terms. Like what if we just said, what if the renewal provision just said there's an option to renew for 5 years at the same rent? Wouldn't that also apply terms? Or if you said that it's effective, wouldn't it be in doubt on your theory whether those other provisions of the lease are still carried forward?
It potentially could. I think it would depend upon the facts of that particular lease.
Okay, so
the facts of that particular process.
In a renewal clause, you just need term and rent amount. And then if that is effective, that you're saying that's enforceable, but going forward, it's in doubt whether all the other provisions of the lease are carried forward, because you didn't say that.
I think it could be, there's an easy solution, which is what the Goldblum case questioned, which is, did the language as set forth in the lease contemplate that the parties intended to carry it forward, or by striking it on the face of the lease suggest that they contemplated something.
So you're saying that I'm correct, that that's what our opinion should say, that unless you specify that every single term in the original lease is carried forward, it's not carried forward.
Well, I think that's what Edgewater holds. And the only issue before Edgewater, and frankly, the only issue the parties are focused on here is the amount of rent. We can see that is the most material term in a lease renewal is the amount of rent and the length of the term.
Well, the fact that your client undertook efforts to enforce what it perceived as violations of the lease sort of suggested you bought those terms for purposes of renewal.
But those were during the initial term of the lease. The renewal wasn't exercised when the ongoing litigation remains pending.
But here, we're going to talk about the absence of a set rent. That's your position. That's all your clients want to do.
What we are arguing is that the term of a renewal is specified. How the tenant and when the tenant can exercise the renewal is in the document.
For all we know, your client may have bought that risk or insured that risk when it bought the property.
Well, that gets at the estoppel argument.
Yeah,
And
knowing that there was this lease and it provides for a renewal, and maybe there is or is not a question as to how much it's going to be. Your client's in the best position to protect itself by negotiating a price that's reflective of that risk.
So we think that's relatively straightforward to deal with, and it's dealt with this way, is that someone who takes an assignment stands in the shoes of the person who makes the assignment and receives all of those rights. And a term that is indefinite is not made definite by virtue of the assignment. Taken to its logical end, the appellant's argument would have the court hold that any party who signs a contract is thereafter prohibited from contending that the term of that contract is unenforceable. And that would obviously turn basic contract law on its head. And that's in fact what the fourth DCA concluded when it rejected the principle of estoppel when there was no definite agreement. And so we think estoppel simply doesn't apply here, and the trial court got that correct. I'll address briefly the stay order. The trial court did enter an order staying other causes of action between the parties. We think that has no effect on this court's analysis. I will concede that the stay order is at best unclear, but what we think it simply means is that the trial court recognized there were these opinions from the third DCA and the fifth DCA that both parties cited, and the trial court recognized it followed that case law. We don't think it says anything else. And regardless, it should have no impact on this court's review because that order is not part of this appeal.
The stay applies to the entire case.
It does. That's right.
Yeah, that's what I'm like. Okay.
The stay applied to the entirety of the proceeding below that includes the claims for breach of contract and possession that remain pending. On the forfeiture cases, since appellant's counsel addressed them, we agree they are not applicable because they dealt with these forfeitures during terms that were ongoing. Here, the summary judgment order was entered during the initial term of the lease before any attempt had been made to exercise this renewal right. And so we think those cases are unhelpful to the court. To return to what the main point of our briefing is that is it sufficient simply to say less, and can that be construed to by nothing?
Be more, is it just less or nothing?
We agree here. Silence is nothing. The parties have said nothing.
If it's less, it will say nothing. You can run about a lot of cases you say.
And that's right. And that's right. And that's exactly the point. Parties have found to have said something, but still found to have said not enough.
Okay, but so address, so your point has to be that it's wrong to say saying nothing is sufficient.
I agree. Saying nothing is insufficient because saying nothing doesn't comply with what Edgewater, Jahangiri, FM3, and LaFountain all conclude, which is you have to.
For that, because the authorities on the other side, where you were saying nothing.
We think those cases support that principle because if
the case, Edgewater and Goldwyn.
They do, and here's how we think
But Edgewater, if you look at one of the footnotes, the holding, I think that you cited, it relies on Williston that talks about where it's meant to, where is it? Where to be future point in time. I think it's maybe it's footnote 7. Although a promise may be sufficiently definite when it contains an option given to the promisor, yet if an essential element is reserved for the future agreement of those parties, the promise gives rise to no legal obligation until such future agreement. And I think that's what is central to those cases that you cited, that there's an element there where the parties affirmatively try to allocate, whether it be method or it be some future agreement or market rate, and it's just too unknown for the parties. But we don't have that here. And I guess that's what I'm struggling with. If you have some other cases that go against that general principle that silence is enough, then I'd like to hear from those.
And I think we might be saying the same thing, which is that those cases conclude that the parties did not say enough. And if the law is the parties did not say enough.
Doing an acrobatic on the Williston principle there, but
so the way we read those cases are, they recite that secondary authority, the massive authority that appellant points to the court is out-of-state authority, secondary authority, all before Edgewater, all before the cases that follow Edgewater, which all uniformly hold the parties must state one of two things: a definite agreement as to the amount of rent, or a definite procedure to be followed to determine the amount of rent. And in the absence of saying either of those things, courts routinely conclude that lease renewal terms are too indefinite.
Okay, that I want to know about. So that comes close to you telling me that there is a case in which the renewal term was silent as to the rent, and that was held by the court to make that renewal term unenforceable. I want you to show me that case. That's what you're saying that is, and show me that case.
So we think that's the Edgewater case.
Because you and I both know that the Edgewater case was turned on the fact that it wasn't signed.
I agree, and I don't mean to
tell me what case. That silence in a renewal term made that renewal, the renewal clause made that renewal clause unenforceable.
So we think that's the consequence of the court's decision in Edgewater for this reason. And I confess, I don't have another case. I don't have another case that.
What case the facts include a renewal term that is silent as to the rent amount, and the fact that the renewal term was silent as to the rent amount led the court to conclude that it was unenforceable because factually the renewal term was silent as to the rent. Which case?
I don't have that case, and I don't know that's been presented to the court by either the appellant or that.
So that's not Edgewater, right?
Well, I think
Edgewater, right?
I agree. The facts in Edgewater did not include the silence that we're faced with here.
Okay.
I think the consequence of the court's decision in Edgewater, though, is that if that court found, as it did, that the parties did not say enough, what the court was then left with was a silent lease that just said you could renew for however many number of years those parties had agreed to.
Here's another one looking at it, correct me if I'm wrong. They're left with an ambiguous lease. And all the other cases say silence is not ambiguous. It implies that the rental amount in the original term of the lease carries over. I don't disagree, but the point that we think that the court ought to take from Edgewater is that if that court had found that silence was truly enough, and the court does recite a mix of law before coming to its ultimate holding, what the court might have done is simply say, okay, the rent carries forward from the original term, but the court didn't do that. The court found the renewal provisions to be unenforceable. And we think, in fact, that I appreciate the court's time, because we think saying less is not sufficient, and because this lease is silent on any agreement as to a definite amount of rent. We think the trial court correctly entered a summary judgment, and that this court should affirm, which would align this court with the third, the fifth, and the first districts, as opposed to pushing the court into new and different territory, as I think Judge Smith suggested. I appreciate the court's time. Thank you.
Mr. McDermott. Mr. Vaca, 5 minutes.
I think the good news is that unless the court has some questions for me, I won't use all of my 5 minutes.
As you wish.
There was a suggestion by the appellee that we could have added language to the lease that said that the lease would renew on the same terms. But there's no explanation for why we would legally be required to add that language when it would be superfluous under the circumstances. The silent portion of the renewal option is clear and unambiguous as a matter of law. It provides that the terms will be the same. So why jinx that possibility by adding language to this agreement when we already had an agreement that was enforceable as to the renewal? I don't really have anything else to add at this point. We would simply request that the court reverse the final declaratory judgment, summary judgment that was entered in favor of Aventine, with directions to the trial court on remand to enter summary judgment in favor of my clients. Thank you very much for your court's attention.
Thank you both. Thank you.